construed strictly and little way can be provided to entertain petition of dissolution of marriage, even when it is presented within a period of 12 months. Then your lordship para 10 months.
ಇಲ್ಲಿ provided that provided ನಲ್ಲ the court shall have regard to the interest of the children of marriage and to the question whether there is a reasonable probability of reconciliation between the parties before the expiration of the provision petition made in this regard. Allow a petition to be presented since presented before 1 year has elapsed since the date of marriage. Rules and
such rules has been made with the High Court.
provided court may allow petition to in accordance with such rules as may be made. ಅಲ್ಲ ಈಗ ಇದು ರೂಲ್ಸ್ ಆಗಿದೆ ಆ ಜಡ್ಮೆಂಟ್ now he is giving
of justice.
Then now we are bound by this.
This
If there is any Supreme Court judgment,
is 2012 judgment, that is 2010 judgment.
whatever 2010 or 12, when there is a 2010 or 12, when there is a coordinate bench judgment of this court, we cannot take a different view unless there is another Supreme Court judgment.
See, there is that judgment. Subsequently, I made the
ನೀವು ಪ್ರಯತ್ನ ಮಾಡೋದಿಲ್ವಾ?
Huh?
You do not try to find out if there is any other
I will
judgment of
find
the
out.
Supreme Court?
I will find out. See, already 5 years, 5 months. Ega, the matter will be this, my lord. The matter is this, my lord. After 5 years, 5 months, if I have to file a fresh petition again, how many years? They have not filed objection to the main petition. They have not come for conciliation. 5 years.
If
And
there was some order 7 rule 11, if there is some inherent bar of law, then court can, even if he has not filed objection, court can
court
reject.
could have said,
We asked
even when recording the evidence, 2
counsel,
years has been given to them.
counsel, see section 14 bars it as it is.
Yes.
There is a proviso. Whether your case comes under the
For
proviso,
that
you have to
reason,
satisfy that.
I made the application section 14.
Yeah, right. Even to allow that application shows that judgment. If there is any other
I
judgment.
will look to it, my lord.
Now, Council Garpala seeks time to examine if there is any judgment of the Supreme Court on the point of in respect of the proviso to section 14 of the Hindu Marriage Act.
Lord, am I audible? My lord, we have disputed the liability, my lord. Driver is implanted, rider of the motorcycle is implanted.
As per the postal record, the respond number 2 alla, respond number 3, Lokesh, has not claimed the notice. Therefore, service on respond number 3 is held sufficient. Registry has placed the counsel is 7990 has placed the memo filed by the lower counsel. The memo filed by the lower counsel for the along with the proof of deposit. The same is taken on record.
My lord, we have already deposited the amount, and yesterday we have submitted the.
Yes, we have recorded that.
Please, my lord.
Yes, we recorded that. Registry has placed that.
Much obliged.
Yes, what do you say for this release
My lord,
of amount?
Release of amount, my lord, we have got
393 days. What do you say?
Delay is there, my lord.
They have also filed cross objection, CROB number 30/25.
Correct. First you submit in your appeal. 393 days delay is there.
ಆಮೇಲೆ
You represent the claimants.
Please, madam.
And ನೀವ್ಯಾರನ್ನು represent madam?
Senior.
Oh, ವಿಜಯ್ ಕುಮಾರ್ ಇದ್ದಾರೆ. Yes. Add down ಮಾಡಬಹುದಾ ಇವ್ರೆ? ಏನದು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್
Court final. Court will be done.
ಕೋರ್ಟಿಗೆ ಬಿಟ್ಟಿದ್ದು ಅಂತ ನಿಮ್ಗೇನು ನೋ ಸೇ ಇನ್ ದಟ್? ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ರೀಸನ್ಸ್ ಹೇಳಿದ್ದಾರೆ. Considering order number 1 of 2024, considering the explanation for the delay of 393 days in filing the appeal is condoned in the interest of justice. IA 1 of 2024 is disposed of accordingly. Yes, what about IA 1 of 2025? Release of the amount?
My lord, release of the amount at the time of accident. And my lord, the PW1 in her cross examination, she has clearly admitted. May I read, my lord?
Yes.
ಅಪಘಾತ ದಿನದಂದು ನಾನು ನನ್ನ ತಾಯಿ ಟಿವಿಎಸ್ ಮೊಪೆಡ್ ಮೇಲೆ ಮನೆಯಿಂದ ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆಗೆ ಹೋಗಿದ್ದಳು. ಮೊಪೆಡ್ ಅನ್ನು ಮುರಳಿ ಎಂಬುವರು ನಡೆಸುತ್ತಿದ್ದರು. ಮುರಳಿ ಇವನು ನಮಗೆ ಸಂಬಂಧಿಕನಾಗಬೇಕು. ಮುರಳಿ ಮನೆಗೂ ನಮ್ಮ ಮನೆಗೂ ಅಂದಾಜು 1 ಕಿಲೋಮೀಟರ್ ಅಂತರವಿದೆ. ಮುರಳಿ ಈತನು ಚಾಲಕನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಾನೆ. PW1 herself in the cross examination admitted Murali was riding the motorcycle, but Srinivas has implicated as a rider, accused rider, because that accused rider is not having Murali was not having driving license. This fellow has been implicated. There cannot be any liability on the insurance company. Let the records be called for and it can be disposed of any time. Even the policy is also, it's a bundle policy, it is expired.
But you are not examining anybody on your behalf.
But we have elicited in the cross examination, my lord. She has clearly admitted when there is a clear admission.
She was not eyewitness.
But she herself says she has filed a petition for claiming compensation for the mother, and she has admitted her relative, one Mr. Murali, was riding the moped.
On the ground that respondent number 1. On the ground that respondent number 1. It is here Srinivas. Respondent number 2 was not riding the vehicle.
Respondent number 1, Srinivas.
That is was respondent number 1.
Appeal, yes, sorry.
Therefore, consideration of IA 1 of 2025 is deferred till the receipt of the TCRs. Admit call for TCRs.
Much
Based
obliged.
on date hearing.
4-6.
4-6.
Much obliged.
Much obliged.
Cell number 13, B. Pradeep.
I am for apply, my lord, regarding council submission, my lord. Insurance company name, my lord. Bajaj Allianz General Insurance Company.
Yes.
Tribunal, my lordship, AN Bajaj Allianz NC instead of NZ.
Just
NC instead of NZ, my
Alliance
lord.
General Insurance Company.
Please, my lord.
Manager Jayant Inamdar. Only quantum.
Please, my lord.
In notional income or
No, my lord, he is engineering civil contractor, my lord. Income taken,
IT returns ಏನಾದ್ರು ಇತ್ತಾ?
they have filed, my lordship, not IT return, but they have filed certificates, my lord. SVT training certificate, employee training certificate instead of.
And training certificate.
Please, my
IA
lord.
1 of 2025.
Meanwhile, call for TCR, my lord.
Call for ಮಾಡಾಯ್ತು.
Please, my lord.
With your lordship, kindly, my lord, in the previous
Wait,
matter, stay may be extended.
27 6 ಆ previous case ಅಲ್ಲಿ stay ನೋಡಿ ಇದ್ರೆ extend ಮಾಡ್ಕೊಳ್ಳಿ.
Much obliged.
Earlier is extended till next date.
Cell number 14, SV Hector Mulkun.
My lord, for the appellant, my lord. My lord, this is also regarding, my lord, the name of the insurance company. My lord, the present General Insurance Company. It was the former name.
Magma HDI General Insurance Company Limited.
Now it is, my lord, Magma
General
Insurance
Insurance
Company.
Limited.
Insurance company.
ನಿಮ್ದ್ರಲ್ಲಿ you are admit call for TCS. 1,20,000 ಅಷ್ಟೇ ಮಾಡಿ.
Other expenses.
Accepting the reasons, accepting the explanation for the delay of and 106 days in filing the appeal is condemned in the interest of justice. I have 1 of 2019 is disposed of accordingly. Records to call for ಮಾಡಬಹುದು. Admit ಆಗಿ ಬಿಟ್ಟಾಗಿ
ಇಲ್ಲ
for final
ಆನ್ ಮಾಡ್ದ್ಯಾ ಇದೇನಿದು ಆನ್ ಮಾಡು.
In 32 minutes, they have filed one memo.
How many daughters are there?
2 daughters.
Where are the records of the this property?
Only the memo has been filed.
Only memo is filed. Where is the record of the property?
My lord, records of the property, if he agrees to take that property, my lord will
How is that, madam? They should know this property
my lord will
How is that, madam? They should know this property belongs to him. There also court also should know.
my lord, all right, my lord, I'll produce the records, my lord, in 2 days. Because that is undisputed. She knows that
He is saying he has to take instruction from his client.
with regard to
And even if you do not dispute, we should know that, no?
no, what he is seeking time is, for what he is seeking time is to place that, my lord,
You produce the documents within 2 days, as you said.
very well.
Register RPFC. Register 16.3. Register is placed. The memo filed by law counsel for the petitioner. Whereunder an offer is made to settle the matter by giving some house property to the respondent and her children. But no documents are produced. No documents of the said property are produced along with the memo. Learned counsel for the petitioner seeks time to produce the documents.
May I
For the respondent.
May I request your lordship to have it on Monday, my lord?
To seek the response of the respondent. Okay. List on
28/4.
you can.
Monday, my lord.
28/4.
Very well, very well.
Cell number 17 adjourned. Cell number 18, Nagendra B. SCP.
Valentine, 18.3, my lord. Lord, in this case, Lord, accused number 1, 3 and first for peace to ask me to produce the bail order he obtained in the other cases. My lord, I may permitted to produce the bail order. But the motive is against the accused number one. The case is, my lord, the accused number one,
Just a minute.
please.
ರಾಮನಗರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತಲ್ಲ ಇದು ಮೊದಲು ಹರೀಶ್ ಕುಮಾರ್ ಅವ್ರು ಮೆನ್ಷನ್ ಆಗಿತ್ತು ನಾವೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತಲ್ಲ SH ಕೇಸ್ ಮತ್ತು SR ಕೇಸ್ ಮತ್ತು SR ಜನ ರಾಜಯ್ಯ ಸರ್ ಈಸ್ ನಾಟ್ ಅವೈಲಬಲ್ ಹಿಯರ್ ಅಲ್ಲಿ ಅವ್ರ ಜೊತೆಗಿಲ್ಲ ಸರ್. In this matter, which is criminal appeal 482, this was assigned to the bench of SHKZ and his companion. That was on 12/7/2024. Now the Supreme Court judgment has come. No? In the trial court, they were on bail.
ಆಗಿದೆ, ಬೇಲ್ ಆಗಿದೆ.
Yes. SC number 82, 12 and 67. This was in which case? This criminal miscellaneous 5356?
That is crime number 82 bar.
Sessions case, in the same case.
Sessions.
He's involved in
Antecedent ಬಗ್ಗೆ ಹಾಕಿದ್ರು last time.
These are the same cases.
ಹೌದು.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. December 5. Yes, what is was granted bail in that case and that.
Lords, one is common intention is there, my lords. They stand on the same footing. However, my lords, as against item number 2, overtact is, my lords, he has using billow, he has stabbed on the back portion of neck of deceased. That is overtact, my lords.
Now 1, 3 and 6 are granted bail.
Yes, my lords.
Appellant circus number?
And it is item number 2, 3 and 5 who took my lords deceased in the car bearing number of my lords K10 A1676.
So PW 13 speaks about the recovery. Kindly see.
It was being submitted that there are certain serious overtaxes are imputed to this accused number 2.
The last time he was in the other cases anta tavu.
ಅಷ್ಟೇ.
But can you see PW evidence of the PW 13?
Accused number 3, belooks here.
Recovery of billooks, 2 billooks, my lords, are the instance of accused number 2.
And it was recovered in open space. And no photograph was produced while recovering the billooks.
He assaulted him on the back of his neck anta ಇದೆ
Yes,
human
ma'am.
allegation. But last time it is observed that the opinion regarding cause of death was inconclusive.
It is pending, my lords, for chemical analysis. However, my lords, he has observed 36 injuries.
The only circumstance against him is now that there is another case, that's all. What is the stage of that case? Trial. Trial.
Salman, kindly see page 13. My lord, PW 13 says, my lord. May I read, my lord?
Page?
PW, 3 page, internal page 3.
Where? Deportation
13.
copies are here.
Trial court record. PW 13. ಪಾರ್ಟಿ ಸವಾಲು ಫೋಟೋಗಳಲ್ಲಿ ಒಂದು ಕಡೆಗೆ ಮನೆಗಳು ಇರುವಂತೆ ಕಾಣುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಆ ಸ್ಥಳದಲ್ಲಿ ನನ್ನ 4 ಸಹಿಗಳನ್ನು
ಎಲ್ಲರೂ ಸಹ ಸಹಿ ಮಾಡಿರ್ತಾರೆ. ಜಾಯಿಂಟ್ ರಿಕವರಿನಾ?
Joint recovery.
Joint recovery, then it's valid. Yes, what you wanted to submit? You've done the appeal better. 482 is our appeal. ಇದು ಅವ್ರದ್ದು ಮತ್ತೆ ನಾವು 482 we were so far seeing 482. Yours is
935.
935.
Accused number 2.
We saw your appeal. Yes, what do you want to submit in that? He should hear you. Take the mic.
And also, my lord, there is no recovery at the instance of the accused number 5, my lord. And also, my lord,
ಎರಡರಲ್ಲೂ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಅಂತಾನೆ ಬರ್ಕೊಂಡಿದಾರಲ್ಲ ಇವ್ರು. ಅಲ್ಲಿ ಸಂತೋಷ್ ನಿಮ್ಮದ್ರಲ್ಲೂ ಹಾಗೆ ಇದೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 5. ಅಕ್ಯೂಸ್ ನಂಬರ್ 5. Yes.
lordship was his only allegation is against my lord. Last seen witness is PW 16 and 18, my lord. They are turned hostile to the prosecution case, my lord. She was not supported the case of
Props calling, my lords. Not 5, 4 and 6.
Past title ಅಲ್ಲಿ
4 and 6, my lords.
5 split up case number 12 of 2000 registered against him. 4.
4 and 6, my lords.
Okay,
Not
5.
5.
6 was absconded.
ಹೌದು.
Right. And first appellant in criminal appeal number 935 2024 submits copies of 2 of them were granted. What is his name? Santosh, Allah.
2 was seconded under body warrant because he was involved in other cases.
The bail orders in criminal miscellaneous number 5353 of 2019 and 5356 of 2019 passed by the 3rd Additional District and Session Judge, Bangalore Rural District. Two cases IA is pending. No?
2 cases. Other 3 cases are disposed of.
18 and 18.3. 18.3. These appellants are case number 2 and 5. No? 2 and 5 in SC number 82 of 2019 connected with SC number 12 of 2021 and 67 of 2021. By the influence judgment and order, they have been convicted. Section 149 IPC, convicted and sentenced anta ಬರೆಯುವಾಗ along with totalization accused, along with other four accused, other four accused for the offences punished under section 123 201, read with section 149 IPC. The allegation against all the accused was that they conspired, due to some ill will, they conspired to commit murder of victim Naveen. It's further alleged that in execution of such conspiracy on 21/3/2019 at 9:45 p.m., they secured Naveen near Kuchiganalu Kanve Marama Temple, Chitradurga, and assaulted him with the bill hooks, beer bottle, and choppers, and committed his murder. It is further alleged that to screen the evidence of offence, they disposed of the dead body between the muddies on the roadside. Admittedly, the case is based solely on the circumstantial evidence. There are no eyewitnesses to the incident. This court, by order dated 4/4/2025, has granted suspension of sentence and bail to accused number 1, 3, and 6. Why you had not argued accused number 2 counsel previous hearing date?
Not,
Their application was not at that point of time.
Not filed.
Yes, ma'am.
Not filed. Appeal pathraith. Though it is contended that accused number 5 was involved in two other cases. ಎರಡು 302 ಒಂದೇನಾ? one the 4 399 400. The copies of the orders in criminal miscellaneous number 53, 56 and 53, 53 of 2019 produced by the appellant's counsel show that he is granted bail in those two cases. There is no allegation of he jumping the bail conditions. The present appellants stand on par with accused number 1, 3, and 6. When it was accused number 1 who had
Yes, motive is.
Therefore, on the principle of parity, they are entitled to suspension of sentence and bail. Hence, the following order: the applications are allowed with suitable condition. They are entitled to with suitable condition. They are entitled to grant of suspension of sentence and bail with suitable conditions. Hence, the following order: the applications are allowed. Appellants accused number 2 and 5 are the impugned order of sentence is suspended against appellants 2 and 5, and they are granted bail in the above cases subject to the following conditions. ಇದರಲ್ಲಿ ನಾವು ಟೂ ಶ್ಯೂರಿಟೀಸ್ ಇದೆ. ಒಂದು appearance before a police station. Accused number 5 has 2 cases, no?
no, my lord, there is no criminal antecedent against the accused number 5.
2 has. Santosh is 2, na? Santosh is accused number 2. We direct him to mark his attendance before the police because he is already facing 2 criminal cases. Apart from this, the appellants accused number 2 and 5 shall execute personal bond in the sum of rupees 1 lakh each and furnish 2 sureties in the like sum to the satisfaction of the trial court. They shall deposit the fine amount before the trial court. They shall appear before the court as and when required. 4th ಇನ್ನೊಂದು appellant accused number 2 month ಒಂದು ಟೈಮ್ ಕೊಡೋಣ ಪೊಲೀಸರು ಬೆಳಗಿನ ರಾತ್ರಿ ಕೂಡಿಸ್ತಾರೆ. ಎಷ್ಟು 10:30 ಅಂತ ಫಿಕ್ಸ್ ಮಾಡೋಣ at 10:30 AM till the disposal of these cases. ಎಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿರ್ಲಿಲ್ವಾ ಇನ್ನು? Yes. ಒಂದು ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ಎಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಇಲ್ಲ? ಒಂದು ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ಫಸ್ಟ್ ಒನ್ ಅಡ್ಮಿಟೆಡ್ ಎಲ್ಲನೂ ಆಗಿದೆ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ದ ಪ್ರಿಪರೇಷನ್ ಆಫ್ list after the preparation of paper books. You communicate the copy of this order to the trial court and the concerned prisoner.
Seal number 19, Brijesh Kadapa, Venkatesh Somreddy.
Yes. Lots of the May. Maybe. Please. May. Give a copy. Copy to you.
He has more solidarity with you. He gives it first, gives first to you and then to us.
I was saying something in lighter way. Lord, if the Lords has been to the Nagpur bench of the Bombay High Court.
No, we don't want your lordships to go, my lords, to any bench. Your lordships to be here only.
Not gone.
Lord, we see two grand portraits. One is of Justice Hidayatullah, the other is of Justice Bogde. And now there will be a third portrait, which will be of Justice Gawai. There will be 3 Chief Justices from Nagpur.
Please.
Vacations have begun in March 26th.
Court order.
And vacations continue till May, 28th to May. I'm only saying, Lord, that let this vacation be divided 50-50. That's all I'm saying.
Yes.
And today, in fact, I'm willing to take a concession.
Judgment copy.
I'm willing to make a concession today, Lord. Let the children be handed over today, Lord. I will return the children on the 20th of May because their children also require 20th of May because their children also require about 7-8 days to get back to their normal rigor. Therefore, let the children be handed over today. We will return the children on the 20th of May. So 28th is the reopening. So we will have 1 week to take care of their interests and to also kind of ingrain them into going back to school.
This is from which place? Mangalore. Children are here.
Children are also in Mangalore. Children are in Mangalore, my lords.
In Mangalore.
Children are in Mangalore. Now, my lord, this is the dispute started from the year 2021 when she was found in a adulterous relationship. And on this point, my lord, petition is filed for divorce on the ground of LL3 with one person, respondent number 2, before the trial court, and also with several other men whom we do not know, identities are not known, but materials are there. So the trial court, judgment of the trial court, concludes, my lords, that she is guilty of 105 of the internal page number 105. There were 2 petitions, one by the wife against the husband, another based by the husband, wherein respondent number 2 is one Dr. Paul, who is the pastor, Paul Palli, pastor of the Cornerstone Church. That the honorable court will get at page number 2 of the internal page number 2 of the judgment. And
In that case, if the Lord is having a full hearing,
in fact, this honorable court had observed that it requires full hearing.
Since it's my application, let me make the first argument.
I'm only placing the facts. I'm only placing the facts on record as it is.
You are saying that it is his application. If you want to touch the merits, saying that it is his application. If you want to touch the merits of the case, he wants.
No, my lords. In fact, this honorable court.
Day 1 of 2025.
In fact, no. Let me place. I'm only placing nothing outside the records. I'm placing only on the records. In fact, this honorable court earlier held, my lords, this requires hearing. Both should file synopsis. Please.
So, if it is his application, what he is saying is, if you want to argue at length touching the merits of the case, he also argues on the merits of the case, touching the merits.
Absolutely no objection, my lord. Absolutely no objection. And matter itself can be disposed of.
Not that.
No, because this honorable court earlier kindly see the orders passed by this honorable court.
Order.
We cannot ourselves. We are duty bound to inform the honorable court what has happened, transpired. 27/9/2024. My lords may kindly go to the order 27. Just because parties engage different advocate, there cannot be new lifeline.
No such
No,
comment.
kindly see.
We also gave custody in that case.
No, one month. I beg to underline this. Once in a month. That is at the home. That shows that the trial court was satisfied, mother and children visitation, so and so. Shows that the trial court was satisfied, mother and children visitation, so and so. Considering the age of the children in the above facts, the appellant is given visitation rights on first Saturday and third Saturday of each month. Kindly see the next para. To avoid an untoward, because there were allegations that she has beaten the children during the visitation. To avoid any untoward incidents, the earlier visitation was in my house. CCTV captures the beating. Avoid any untoward incidents between the parties making allegations against each other. Visitation shall take place in the premise of the District Legal Service Authority, Dakshina Kannada, Mangalore. The member secretary so and so shall facilitate visitation within the premises of so and so. Respondent shall drop the children in his presence at 2 p.m. on first Saturday and third Saturday. Pick them up at 5:30. This arrangement shall continue till next hearing date. Between 2 p.m. so and so, appellant shall spend time with children. Communicate this order so and so. Connect 20th January 2025. Under IA number so and so, appellant is seeking direction to respondent number to hand over the custody. The records show the trial court has granted decree of divorce on the ground so and so. Court in IA number so has granted visitation rights to the appellant on first and third Saturday at the house. So this is fresh application, my lord. On finding for the first time, this sort of application is filed because I'm using the term first time because to the 19 onwards, no such application before the trial court. To the 19 matter, my lords. MC is up to the 19 before the trial court. What was going on before the trial court was this, my lords, visitation rights twice in a month, continuously. And during that period also, there is abuse, there is beating, charge sheet is filed. Of course, on a technical ground, my lord, that stayed. But charge sheet is filed because CWC recorded the statement of the children. Magistrate recorded the statement of the children. There is a video showing that they were beaten up. And here is a case where a short time children is with her daughter. His daughter is aged now 12 years. Son is aged 9 years. When the daughter is for a short time, she could not get the custody before the court. Court said, no, we can't give custody because moral development is required. Documents show that you are entertaining male guests and sleeping with them in the night. Daughter statement before the magistrate in chambers, before the police. A bore note from the records. In her diary, she writes, I'm happy sleeping with so and so pastor. And Oliver is the husband. I'm maintaining contact him only for the eye wash. And everything is on record. And the magistrate holds that they are not entitled to, my lords, under the DV proceedings. DV proceedings. No application is filed to amend, to modify it. Appeal is taken up. Final disposal, IA, after hearing both parts, children were called to the charge. I would have been in custody. But if false charges, this is happening. This is a very grave situation in her own handwriting. She lodges the complaint. And kindly also kindly appreciate my agony. Such a sort of allegation. She goes to that extent because she is in, and she says she is going to marry that pastor in her own handwriting. All these, my lords, records before the learned magistrate, my lords, and also before the honorable family judge. Now, family judge evidence has been led. Number, she challenges the magistrate's order under the DV Act, all same orders, my lords, before the honorable district judge, session judge under section 29. Section 29, session judge says, yes, I have confirmed the order. That attains finality. On the DV side, it attains finality. When it comes to the family court, my lords, she never filed such an application before the family court at any point of time for custody, wholesome custody, either during Christmas or vacation. This is the first time such an application is being filed, my lords. Children were called to the chambers before the session, family judge, before the magistrate, before the session judge under appeal, for the honorable high court also earlier, where they categorically say this, and there is evidence. Video recording also, my lord, showing the assault. Now, my lord, why I produce these records? Kindly appreciate.
Now, what
Please.
happened during visitations keep on coming? Why?
I'm willing to argue the main matter.
Yes, it can be disposed of.
But I'm only saying,
Because both of you are directed to submit your
Yes, we are.
judgment is very lengthy.
Oh.
Trial court judgment. So that's why we were
In fact, my
asking
synopsis is ready, almost ready.
may I just say this?
And these orders were passed on hearing both of you.
That's it. No, I'm only saying that exactly the same allegations. Exactly the same allegations exactly the same allegation. One regarding the same thing, exactly the same, verbatim were repeated. Sometimes there is an order of this court on 20th May 2021. All these allegations have come. I will allow you to show the record below.
20th May 2021.
2021. My lords, Justice Mughal had passed this order.
That is in.
That's in the criminal petition.
Exactly the same argument.
Correct. There the scope.
There was
The scope is there and here are
But
different.
that's right, but I'm saying, my lords will then examine the paper book. I see these same allegations and I will prove it.
We'll argue, both of us will argue on merits.
Allegations have been made. 1 minute, sir. I didn't.
Hey, why do you get?
I didn't interview.
No, I will not. I am addressing the Honorable Court. I'm praying the Honorable Court.
The same
Correct.
allegation.
Now you tell us. After hearing both of you, these orders are passed.
Yes, sir.
You do not argue and complete the matter before vacation. You go on filing applications. How many vacations are over now from 2019 till now? At any time you have sought the custody of the children during the vacation? 2019 till now. At any time you have sought the custody of the children during the vacation?
But
Even in this appeal is pending since when? 2024. When it is filed?
Christmas villa.
10th June 2024. Now,
Christmas bantu.
no, Dasara vacation,
Dasara.
Christmas vacation have gone. At any time, had you sought custody during vacation?
not only for this reason. The liberty has been offered to us.
Changed circumstance, we had said.
Change circumstances, exactly. And I'm saying, let me.
Not change lawyer.
80 of 2024.
It is your appeal always. Page number 100 and
103.
internal page 103.
External page 103.
Yes,
By considering all these aspects, I have the opinion that the custody.
yes.
By considering all these aspects, I have the opinion that the custody of minor children, which is with the husband, the respondent husband by way of interim order, if the same is cancelled, there is likelihood of cause effect with paramount interest of children. And also the petitioner wife being the biological mother of the children if she does not have visitation rights. Naturally, it affects her affectionate love with the children as because naturally the mother also has love and affection towards the children. Earlier also, the so-and-so had granted visitation rights to the petitioner's mother to visit the children at respondent's house on every Saturday and Sunday from so-and-so, so-and-so. Said order is passed while passing interim order. Here, in the present case, minors were going to school, they have to do their homework during the weekend in such a situation. If visitation right of the children is granted to the petitioner, every so-and-so, the same will assist the study of the children. Under such circumstances, petitioner mother of the children is granted visitation right of the children last Sunday also. It is sufficient also there is likelihood of disturbance caused to the study of the minor children. Respondent shall cooperate with the visitation rights and the same will be meet the justice. Next paragraph is important. Respondent husband has sought permanent injunction, restraining the petitioner from causing any threats, any interference in marital injunction, restraining the petitioner from causing any threats, any interference in marital custody of minors. Such a relation of matrimonial dispute between petitioner and respondent. As that touchstone being touched by the trial court, that is the issue. Here, the trial court comes to the conclusion that my client now has an adulterous relationship. For a moment, I will concede that there may have been an adulterous relationship. I'm not saying that there is an adulterous. Still, the Supreme Court has held, Lord, in Mukta Agarwal versus Vineet Gupta, 2024 SC Online 678, that even if a person is in an adulterous relationship, that doesn't change the relationship between the child and the mother. Even if the person is in an adulterous relationship. I'm saying that the touchstone of section 65B has not been convincingly answered. Despite that, I'm still saying that if there is an adulterous relationship, still that relationship between the mother and children doesn't change. Still that relationship between the mother and children doesn't change. How can then the mother be denied custody without his statement that the child is beaten? Does not the mother have the right to beat a child? Are we not being beaten by our own mothers? What kind of an argument is this? That somebody has beaten the child, therefore you can't meet the child, you can't interact with the child, you can't live with the child, even if the mothers are prostitutes, with the greatest respect. Can she be denied the permission to stay with the child? The child is not during the course of menstruation. Who is to guide her limit on how she goes about her daily work? The father? What does he know about the cycle, mother?
That's all. Yes. That's all your arguments. That's all your arguments. No, no, no. Your own. Yes.
And as two children, I've been taking care of children. I mentioned the statement objections that how the children are now developed in the most moral manner. And my lords, this is not a change. It's criminal case is stayed, my lords. But I beg to submit. When it's only a stay is for the criminal proceedings. I concede that is stayed, my lords. Stay is for the criminal proceedings, but the statement record 164 CRPC, statement recorded by Child Welfare Committee, the video, they cannot be wiped out from consideration of this Honorable Court, my lords. And the Honorable Court is considering it for the purpose of knowing whether there is a threat to the children. And children were called to the magistrate and to the family judge, my lords, in the chambers. They have interacted. May I pass on with kind permission, my lord, to summarize my submissions. Short is enough. Please. This is only to shorten the entire brief, my lords. It is about the page number 1 is about the birth, etc., my lords. Kindly go to page 2. Page 2, that's 2018, which are marked documents. Right side I mentioned, which is marked as so and so. This is her own diary in an extracted portion, my lords. Page 2 only extracted portions. It reads a very, very shocking thing. In the presence of the children, everything happens. And how she mentions in her own handwriting, it's admitted by her in the cross-examination also, my lords. And serial number 8, the children. I'm sorry.
Many times will be
I'm sorry. I made a short note, my lords. That's all. Children continue with the father. There's a grave threat to their life. One para. Page 7, please, my lords. Only one thing. Page 7. Page 7. Serial number 22. Pursuant to the orders of this Honorable Court remanded back and said the psychiatrist should psychological assessment must be done to the children. Expert did the psychological assessment under as per the orders, my lords. And it's what? Last line, my lords. Last line. This is in the report. Page 7, last line, last sentence.
Yes.
Serial number 24, when she files a false complaint. Then serial number 25, when there is the police department and the investigating agency conducts that inquiry, my lords. And finally, serial number 28, my lords, after the remand, page serial number 28, children were called to the chamber of the judge. And then the order came to be passed, my lords. That's serial number 29, interim order granted. Appeal confirmed, serial number 30. Wherein serial number 31, the appellate court says, my lords, there also appellate court interacts, my lords. And that has not been challenged. I beg to stress on this. 2021 order has never been challenged. That has attained finality, my lords. Serial number 32 about the documents. Then, my lord, FIR is registered, page 33, 20th December 2023. It is during the visitation, my lords. And I don't want to display it, my lords. We have brought it. It shows a very ghastly picture how children are beaten up. In the plate, my lords, we have brought it. It shows a very ghastly picture how children are beaten up. During visitation, during the CCTV footage in my house. Their statements, etc., my lords.